Just go once we're on. And I'm live. Okay. We're back on the record in the Gatlin matter.
Right out of the gate, this courtroom session sets a tone that's procedural on the surface. But underneath, there's a lot happening that most viewers miss. You're watching what looks like a simple plea hearing, but in reality, this is where a defendant's entire legal trajectory can quietly shift. Miss Gatlin is stepping into a no-contest plea, and that phrase alone carries serious weight. It doesn't mean innocence, it doesn't mean guilt, it's a strategic move. And already the court is laying out the framework. One charge stays, another gets dismissed. That's negotiation in action. Notice how quickly both sides confirm the agreement. That tells you this deal was worked out before stepping into the courtroom. These moments are not spontaneous, they're calculated. And here's where it gets interesting. The defense is citing lack of memory as the basis for the plea. That's not random, that's a legal shield, one that allows the defendant to avoid directly admitting guilt while still accepting consequences. Now ask yourself this. If you were in her position, would you take a deal like this to avoid trial? Or risk everything for a chance at full acquittal? Because from here on out, every word matters. Every "yes, sir" locks in rights being given up, and the judge is about to make sure she understands exactly what she's trading away.
So my understanding is she's going to plead no contest to the use of a controlled substance, a 1-year offense. The basis for that is lack of memory in terms of the no contest plea. Upon her successful plea to that charge, count 1 would be dismissed. There's no objection to 7411. That's the court's full understanding of the agreement.
That is our understanding as well, Your Honor. And that's what Ms. Gatlin and I talked about Tuesday.
That's correct, Your Honor.
All right. Ms. Gatlin, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name for the record, please.
Well, Gatlin.
All right, you can put your hand down. Okay, you already did. All right, ma'am, it is this court's understanding you're going to plead no contest to the charge of use of a controlled substance. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court cost. Do you understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. Let me explain 2 things just to make sure that you understand. The first thing you need to understand is that it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
This is one of the most critical lines in the entire exchange, and it often flies right past people. The judge is making it crystal clear. A no contest plea might sound softer, but in sentencing, it hits just like a guilty plea. That distinction is everything. Legally, it protects the defendant in potential civil cases, but criminally, the consequences don't change. And look at how the judge breaks it down step by step. This isn't just formality, it's protection. Courts are required to ensure that a defendant is knowingly and voluntarily giving up their rights. That includes the right to trial, the right to confront witnesses, and even the right to remain silent without it being used against them. Now here's where the tension builds. She's not just agreeing to a charge, she's agreeing to skip the entire trial process. No jury, no defense witnesses, no cross-examination. Everything ends right here. And notice something else. A different judge will handle sentencing. That introduces uncertainty. The person accepting the plea is not the one deciding the punishment. So think about it. Does that make this decision riskier? You're accepting guilt without even knowing how strict the final judge might be.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge. And you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, sir.
All right. Now, understanding all of that, do you still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal over it.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, sir.
Or plead no contest, I'm sorry. Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes.
All right. The court has been provided and has reviewed Ypsilanti Police, or I'm sorry, Eastern Michigan University Police Department report for their case number 203781. Any objection to the court reviewing that report?
No, sir.
No, Your Honor.
Upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
This is the legal checkpoint that validates everything that just happened. The judge isn't just taking her word for it, he's confirming that there's enough evidence in the record to support a conviction. That's called establishing a factual basis, and without it, the plea wouldn't stand. What's interesting here is how quickly both sides agree. No objections, no hesitation. That tells you the evidence likely isn't being challenged, it's being accepted as part of the deal. And then comes the payoff, count 1 gets dismissed. That's the incentive. This is why defendants take plea deals. They reduce exposure. Fewer charges mean less potential punishment. But then the tone shifts. The judge starts discussing bond conditions, testing requirements, and supervision. This is where reality kicks in. Even though she's not being sentenced today, odd restrictions begin immediately. And did you catch that moment where the judge cuts her off mid-sentence? Hold on, let me finish. That's authority. That's control. Courtrooms run on strict order, and even a small interruption can change how a judge perceives you. Sometimes it's not just what you say, it's when you say it.
People are satisfied.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
October 18th at 9 a.m. for Judge Barr.
October 18th.
Yes.
October 18th, 2023, 9 a.m. And that is before Judge Barr. As to the defendant's bond, and the record should reflect, we had a conversation off the record regarding some things, and they don't need to, in this court's mind, be stated on record. I'm going to reduce the defendant's bond to a $10,000 personal recognizance bond. Ma'am, as a condition of your release, I'm going to indicate that you are to initially what I'm going to want are 2 times per week testing. All right. Drug testing. You understand that, ma'am?
Yes, the only problem is
Hold on. Just hold on. Let me finish. Your attorney did a very good job. So you're going to start talking and mess it up.
Okay.
All right.
Right.
Okay.
Okay.
I'm going to, she told me that you do live in Wayne County. So what I'm going to do is I'm going to allow you to test in Wayne County, but you have to make sure they're going to release the results to our community correction. Okay. Anything else you want to say to mess this up or no?
No, sir.
I didn't think you did. Okay. Thank you.
Thank you.
You're welcome. Sometimes you just got to let the attorneys do their work.
You're right.
All right. We can, whatever anybody might be ready on. Okay. I'll try to take some of them.
Our first one.
Right. Court calls the case of People versus Christopher Page. I was ready in that video.
Nicole Hughes on behalf of the people. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Christopher Page, who appears by Zoom. Mrs. Page, could you state your name for the record?
This is Keith Page.
Your Honor,
Okay, what are we doing?
today's date and time set for a competency review hearing. Does the court have any updated reports of this matter?
I do not.
Nor do we, Your Honor. That being the case, we believe that an adjournment is in order to allow CMH to get the information to us.
All right, so here's what I'll do. I'll adjourn the review hearing. We'll go out 30 days and we can move it up if we receive a report. So I'll adjourn to September 7th, 2023 at 9.
Thank you very much, Your Honor.
Now the pace shifts, and we move into a completely different type of proceeding, a competency review case. Unlike the previous plea, this isn't about guilt or innocence yet. It's about whether the defendant is mentally fit to even stand trial. And notice how quickly this gets adjourned. No reports, no updates. That's a red flag in itself. When the court doesn't have the necessary psychological evaluations, everything stops. Because legally, you cannot proceed against someone who may not understand the charges or assist in their own defense. This is one of those behind-the-scenes realities most viewers don't think about. Trials aren't just about evidence, they're about capacity. If the system determines someone isn't competent, the entire process pauses. And here's the strategic angle. Delays like this can stretch cases out for months, sometimes longer. So the question becomes, are these delays helping the defendant or just prolonging uncertainty? Because either way, justice is now on hold.
Thank you.
Your Honor.
Bond, continue.
Thank you.
Thank you. Why don't we, I'm going to take a break. Probably.
John Hart.
Alex Chabalowski on behalf of the people.
Your Honor, Gina Noveski, First Assistant Public Defender, with and on behalf of Mr. Hart, who is present. Mr. Hart, can you turn your camera on and say your name? He's been on there.
I know he's here, but
Yeah. He must have stepped away for a second, Judge.
he looked like he was sleeping.
Yeah.
Maybe.
Taking a nap. You want to try to call him to wake him up? Are we
Sure.
doing a plea?
Yes. Yes, we are.
All right. If I gave Brown a call, I'll let you do it. Noveski comes in here and just messes everything up too. All right, fine. I'll pass it.
All right. Thank you.
Court calls the case. People versus Zachariah. Is it Ruska Dennis?
Alex Chabalowski on behalf of the people.
And Alex Warren Green on behalf of Mr. Haruska Dennis. Mr. Haruska Dennis, if you're present, would you please state your name for the court?
Not checked in. Ruska Dennis? No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
This is one of the fastest and most unforgiving moments in the courtroom. No appearance, no explanation, and immediately, a bench warrant is issued. There's no warning, no second chance in that moment. If you don't show up, the court assumes non-compliance. And just like that, the situation escalates from a scheduled hearing to an active warrant. And look at the bond set, $10,000 cash surety. That's not random. That's the court increasing pressure to ensure the defendant shows up next time. This is where the system becomes strict. Court dates are not optional. Missing one can turn a manageable case into a much bigger problem instantly. Now think about it. What could cause someone to miss a hearing like this? Negligence, fear, or something more serious? Because whatever the reason, the consequences hit immediately.
Court does call the case the people versus James Jones.
Allie Zend on behalf of the people.
Ron Brown appearing on behalf of James Jones.
Two cases. James Jones? Oh,
Yes, Your Honor.
All right. State your name, sir.
James Jones.
Thank you.
Can me and my attorney go in the breakout room?
You got to call me, Mr. Jones.
Anytime but right now.
Okay.
What are we doing?
Motion for
request-
discovery.
I'm requesting adjournment because I called Mr. Jones several times.
What number you got? brother?
We'll talk.
Probable cause conference, August 31st, 2023, 9 a.m. Bond will continue. Mr. Jones, I'm going to suggest you call the prosecutor, call the public defender's office. Make sure they have a valid phone number for you as well as email.
Yes, sir.
Thank you. Do that right after you hang up. That way you guys can get in touch with each other. Bond, continue.
Thank you, Your Honor.
Thank you. I have 2 recalls.
Go for Cameron.
Which one? Court recalls the case of the people versus Benjamin Cameron.
Maria Rosinski on behalf of the people.
Ron Brown appearing on behalf of Mr. Cameron.
Mr. Cameron, state your name.
Benjamin Cameron.
All right, are we doing the plea form I have?
Yes, Your Honor. It's a no contest plea. Potential civil liability is the basis.
So I should change this on the form to a no contest. Good thing, because I read the report. All right. The plea form indicates that he's going to plead to the charge of false pretenses, 200 to 1,000, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed.
Here we go again. Another no contest plea, but under completely different circumstances. This time, the key phrase is potential civil liability. That changes everything. Unlike the earlier case, this defendant is likely trying to avoid admitting guilt because it could be used against him in a civil lawsuit. If he said guilty, that admission could directly impact financial damages in a separate case. So the no contest plea becomes a shield. It resolves the criminal matter while limiting exposure in civil court. And then there's restitution, over $1,000 already paid. That's a strong signal. It shows accountability, and it often works in the defendant's favor during sentencing. But here's the bigger picture. This isn't just about punishment, it's about damage control. And it raises a key question. Is justice about admitting fault or simply resolving consequences?
There's an agreement, well, there's at least an understanding that the defendant has paid restitution of $1,033.96. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor.
Basis for the no contest plea.
Potential civil liability.
All right, Mr. Cameron, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name for the record, please.
Benjamin Cameron.
Sir, it is this court's understanding you're going to plead no contest to the charge of false pretenses, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property, which is the subject matter of the false pretenses. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, well, let me ask you this. Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about a no contest plea I have to make sure you understand. The first thing you need to understand is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Correct.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
And you understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Okay.
You understand that?
Yes, sir.
All right. Still wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Okay, really?
Now,
excuse me, no contest. Sorry.
All right.
All right.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
I understand.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel your attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, Your Honor.
You understand also you're giving up your right to appeal of right.
I understand.
All right. Are you on parole?
No, sir.
Are you on probation?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest to this charge?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
The court has been provided and has reviewed Northfield Township Police Department report for their case number 20369. Any objection to the court having reviewed that report?
No, Your Honor.
Mr. Brown? Mr. Brown, any objection to me reviewing the report?
No objection to reviewing the report, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Once again, the court confirms the factual basis, and just like before, the plea is accepted. But what stands out here is what happens next. The discussion about restitution being released to the victim. This is where the case shifts from legal theory to real-world impact. Money is being transferred. Harm is being addressed. And the court is actively ensuring that the victim is compensated. But even here, there's hesitation. The judge wants coordination with another court to make sure everything is processed correctly. That tells you something important. Even after a plea is accepted, the system still requires precision. Nothing moves without proper documentation and verification. And this is where viewers often underestimate the process. It's not just about rulings, it's about execution. Because justice isn't complete until the outcome is actually enforced.
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing will be
September 11th at 1 p.m. with Judge Freshour.
September 11th, 2023, 1 p.m. before Judge Freshour. Bond will continue.
And
Thank you.
Your Honor,
Thank you, folks.
Thank you.
Thank you.
Your Honor, for the record,
Yes.
restitution was posted as a bond and needs to be released to the victim.
I'm sorry. The $500.
1,033.
Yes.
Okay.
$1,033.96.
All right. And you'd like that released or right now? Counsel?
Yes, to the victim.
Okay. So we're going to, usually what would happen. All right. I will order that. I don't have a problem ordering that, but I'll indicate restitution. 103396 may be released to the victim. And Madam Prosecutor, you probably want to contact the 1483 court just to make sure that they have all of the information to properly release that. But I'm not going to have a problem with them releasing it at this point. Okay?
Okay, thank you.
And another thing. Thank you. Court does call the case. People versus John Hart.
Alex Chabalowski for the people.
Your Honor, Gina Noveski, First Assistant Public Defender, with and on behalf of Mr. Hart, who is present and on video.
Mr. Hart, can you state your name?
John Joseph Hart.
All right. I have a plea form before me. Is that what we're doing?
Yes.
Yes, Your Honor, we do need to add, I think, the restitution to the plea form, if the court wouldn't mind.
Sure. I don't have anything else to do. What do you want me to add?
$65.62.
$65.62. 65.62.
Yes.
Thank you, Judge.
Thank you.
Hey, Mr. Hart, can you raise your right hand, please, sir?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name for the record, please.
John Joseph Hart.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the third degree. That is a misdemeanor, punishable by up to 93 days in jail, up to a $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, sir, I do.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
I understand.
All right. Still wish to plead guilty?
I do, sir.
And to that charge, how do you plead?
I plead guilty.
This is a different scenario entirely. A straight guilty plea. No legal buffer, no strategic ambiguity, just a direct admission. And notice how the judge immediately walks through the consequences. No trial, no witnesses, no presumption of innocence. Everything shifts the moment those words are spoken. But here's what makes this moment powerful. The defendant explains what he did. He admits to taking groceries without paying. That's not just a legal admission, it's a factual one. And in many cases, that level of honesty can influence sentencing. Courts often consider cooperation and accountability when determining punishment, but it also closes every door to defense. Once you plead guilty, there's no going back. So the real question is, does honesty reduce consequences or just finalize them faster?
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir, I understand that.
Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yes, I understand, sir.
You understand you're giving up your right to appeal of right.
I do understand.
All right. Are you on probation or parole?
No, sir, I'm not.
Has anybody promised you anything other than what's been stated here today to get you to plead to
No,
this
sir,
charge?
they have not. They have
Has
not,
anybody
no.
threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes, sir, I am.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
March 10th, 2023, at the location of 312 River Street in city of Ypsilanti, Washtenaw County, state of Michigan. What'd you do at the Ypsi Food Co-op that makes you think that you're guilty of this offense?
There, sir, took groceries.
Okay, so you went in there, tried to take things without paying for them and tried to walk
Yes,
out?
sir. Yes,
Store was
sir.
open to the pub. Was the store open to the public at the time?
Yes, it was, sir.
You didn't have anybody's permission to take that property, did you?
I did not.
And the property you took, that was property that was offered for sale by the co-op?
Yes, it was.
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed pursuant to the plea agreement.
This is the moment where everything becomes final for this defendant. The court has officially accepted the guilty plea. Count 1 is dismissed, and now the case transitions into the sentencing phase. That shift is critical, because once a plea is accepted, the focus is no longer on what happened, but on what should happen next. Notice how the judge orders a pre-sentence investigation, PSI. This is not just paperwork. It's one of the most influential factors in determining the outcome. The PSI digs into the defendant's background, criminal history, personal circumstances, employment, behavior patterns, and ultimately provides a recommendation to the sentencing judge. And remember, just like earlier, a different judge will decide the sentence. That introduces another layer of unpredictability. The defendant has now committed to guilt, but the final consequence is still unknown. Also, the bond continues. That means the court still expects full compliance. showing up, following conditions, staying out of trouble. One mistake here could undo any goodwill earned through cooperation. So here's the key question. After admitting guilt, does the system reward compliance or simply proceed to punishment regardless? Because from this point forward, every action outside the courtroom matters just as much as what happened inside it.
Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
October 18th at 9 a.m. with Judge Barr.
18th,
Yes, sir.
October 18th, 2023. What time?
9 a.m.
9 a.m. before Judge Barr. Bond will continue. Thank you.
And I thank you, sir.
Thank you, Mr. Hart.
Thank you, Gina. Bye-bye. I'll talk to you.
Okay.
That does that block?
What you've just witnessed across this entire session is a powerful snapshot of how the courtroom system actually functions. Not in dramatic trial scenes, but in these quieter procedural moments where decisions carry long-term consequences. Multiple defendants, different charges, different strategies, but one consistent theme: resolution through negotiation, not trial. You saw no contest pleas used as legal shields, guilty pleas used as direct admissions, and even a bench warrant issued instantly when someone failed to appear. Each outcome depended not just on the facts, but on behavior, preparation, and timing. And then there's the role of the judge: firm, controlled, occasionally sharp, but always focused on maintaining order and ensuring that every defendant understands the weight of their decisions. The biggest takeaway? Most cases never reach a dramatic courtroom showdown. They're resolved right here, in structured exchanges, legal agreements, and calculated choices. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.